Welcome to the University of Western Sydney School of Law series on Views from the Bench. It is my pleasure to again introduce former Justices Coleman and Collier, who are both adjunct professors here in the law school. Both gentlemen have agreed to participate in a series of Views from the Bench, and today's topic is looking at understanding disputes and which disputes are most appropriate for consideration by way of alternative dispute resolution. Gentlemen, tell me, when you were both at the bar, what were your thoughts about ADR at that time?
Well, we're talking about two different times in my case, separated by about a quarter of a century almost. Previously, I had no enthusiasm for ADR whatsoever when I was at the bar before, other than cases where or situations where our case was pathetically weak and almost certain to result in a loss if we went to court. Then I might have been a bit interested in what passed for ADR, but by and large, as a barrister, my role was to get into court and do the best I could in the litigious context. My view is different this time around because you just can't not embrace and be seen to embrace ADR for a whole lot of reasons, not the least being that it's likely to come back and have consequences for your client if you are not very careful about trying to resolve disputes. More than ever, I think, in being back in practice as I am, the ADR and the call-to-bank offer tend to go hand in glove, and in most cases the question is, will we make the call-to-bank before we go to mediation or will we make it after? And that's a tactical decision, but it is almost inevitable that at some point the call-to-bank will materialise. So,
Ian, somebody interrupted. For the students, could you just particularise a little more detail
sure.
about call-to-bank?
Call-to-bank was an English decision in, I think, 1948, the effect of which was that you can make an offer to settle which is without prejudice save as to costs. The effect of that is that the judge can't be told that there has been an offer to settle prior to judgment, but when judgment is delivered, if the judgment happens to be as favourable to your client as the offer was, or more favourable, you call for production of the offer, you tender it, and you seek indemnity costs from the time the offer is made, and the call-to-bank offer itself makes clear that you will seek costs and that you'll seek them on an indemnity basis.
An indemnity cost as opposed to party-part or sister-client?
Yes, yeah, indemnity or solicitor-client costs are in essence all of a party's costs as opposed to party and party. The difference, broadly speaking, in mathematical terms, is usually about a third, or perhaps put another way, party and party will usually be about 2/3 of indemnity or solicitor-client costs. The difference is essentially the time that the solicitor needs to take in dealing with the client as opposed to dealing with the other party.
So it's still a very effective mechanism.
I think so, and with legal costs the way they are, as we talked about in an earlier session, the call-to-bank, in every case in which I'm involved, commercial cases, particularly the call-to-bank of insolvency cases, insolvent trading claims, they're used all the time in commercial litigation.
Yes. David, any further thoughts on that in relation to which matters are suitable in the days when you were at the bar, before you went to the bench, as to what the relevance and benefit of ADR then was for you then?
Well, I agree with Ian. Our function was to get matters into court and try and win them, or at least try to avoid losing them badly. And there was some informal ADR, if you can call it that, but that wasn't based so much necessarily on the case or the parties. It was usually based on your opponent. Was there someone you could sit down and talk to in a sensible way, with or without your client? to see if a resolution could be reached. Certainly when the Family Law Act came in, or within a short period of that coming in, we started to see the registrar-driven conferences that were a form of alternative dispute resolution. And they were mandated by the Act. And speaking for myself, I certainly learned some new skills, or I'd like to think I did, appearing before various registrars at the time, and I will not mention names, on the various techniques you had to use, the various techniques you had to use there, either to try and reach a conclusion or, where necessary, extract yourself with a minimum of pain and loss. But certainly since I was on the bench, it became more and more and more part of the practice of family law. Parties did often attend mediation, not only to try and settle, but to try and reach some agreement as to what the issues in the case were, and sometimes, quite cynically, to try and find out what the other party had in their hand. And that was done, I suspect, more often than I'd like to think.
May I interrupt? How would you, as a judge, if you thought that the parties were not participating in the ADR process in good faith and perhaps using it as a fishing expedition, did you feel that you had a role to play here from the bench in relation to practitioners doing that?
I regret not. There was nothing I could do. I couldn't ask questions about the mediation for fear of, well, simply for fear of putting myself in a position where I could not continue to hear the case, costing everyone money and time. So to that extent, if the parties told you they had mediation, apart from asking when and before who, which was often something that gave you a fair clue, that I felt was all I could do. I don't know if you agree.
No, that's, look, as a matter of law, that's absolutely correct. There's just, and coming back to something David said in an earlier session, and I think we will all agree, there are cases where it is better and will prove to be better for everybody just to get on with having a trial of the issues. Not every case is suitable for mediation. The other thing is, I think you've got to give credit to the legal profession. Contrary to what a lot of people would like to think, with very, very, very few exceptions that I can think of in 40 years as a barrister, lawyers aim to get their clients the best outcome they can in the most cost-effective way. And if it gets to trial, they've been through all the ADR, there's a presumption, in my view, that the lawyers have done their best to try to settle, and there is a good reason why the parties haven't settled. Very often a case starts, and this is the same in every civil jurisdiction, probably criminal too. A case starts and runs to judgment, and from the minute it starts, there's only one person in the courtroom who doesn't know what the outcome is going to be. But of course, it only takes one party. Often that party even knows what the outcome is going to be,
but simply won't concede.
The process is, I think, it's those who have sort of practiced for a long time, as we three have, I think have an ingrained appreciation of just how wise the saying that justice must not only be done but be seen to be done really is, because the number of litigants who move on with their lives after what to us as lawyers is a devastating loss, without appealing, without wanting to blow people up or set fire to buildings or anything like that, is, I am sure, because they take the view that they've come to court, the judge has listened, and the judge has provided some reasons which they may not agree with, but which they can accept, having had a fair go, for why they lost. And it's important that, and good judges recognise early on the cases that are going to be in which the public interest, the private interest, the rule of law, and the welfare of society will be better advanced by just sitting for 2 or 3 days, letting the trial run, treating people with, no matter how ridiculous the arguments, as long as there's the the appropriate level of courtesy and respect for the court is preserved, let them have their day in court. Most of these people are genuine. They're not deliberately trying to be ratbags, and give them a reasoned judgment, and most of them will get on with their lives. And I think that's the important thing, is you mustn't try to, and we've seen, without going back over it again, I think we saw that in 1980, what happens when you and that's a very important thing, and when you get into the ADR process too, it's very important not to let, as David alluded to earlier, not to let the process itself become an instrument of abuse. Because a lot of people go to ADR with no intention of compromising. They go to either find out information, as you said earlier, they go to run the other party out of funds a little bit more if they're in a stronger position. They go because all the marriage or all the partnership or all the time the corporation existed or whatever the commercial arrangement was, the other party was in the habit of giving in to that one, so why would it be any different at mediation? So let's go to mediation. There's a whole lot of, it's not a panacea.
What do you think in terms of the available processes within the ADR umbrella? We have mediation, we may have expert determination, facilitative negotiation, a range of options. How do you, from the bench perspective, determine which would be best or be more appropriate? And could you make recommendations to guide the parties in that direction, or again, are you bound simply by the rules of court, to go to mediation, where there may be other options like mediation, arbitration, mediation, those sort of hybrids that have developed in ADR over the years?
I think all of that has happened before it comes to us. There is the rare case that you would see where you would perhaps say to the parties, have you considered private mediation? I'd like to think that's as far as I ever went in making that suggestion, knowing what they'd been through before they got to us. But we're not in a position to approve or disapprove of the type of ADR they did, when they did it, who they did it with. Ian said earlier, and he's completely right, that once they've got to us, our job is to render a judicial determination.
Yeah, I think that's right. Arbitration, I struggle a bit with the concept of arbitration being under the umbrella of ADR, because arbitration, in my experience, and it's limited to a couple of very, very, very long building arbitrations, I have to say. But my experience of arbitration is that it is, in effect, a parallel judicial system.
Well, an award is a judgment.
Correct.
For all intents and purposes.
Yeah. The attraction of arbitration is potentially that the arbitration is governed by the rules that, in effect, the rules of engagement for the arbitration. And if you're looking at commercial matters, it has some attraction because it can be confidential in ways that litigation of that kind would not be.
There's also the elements of binding.
Bindingness, yeah. But also too, if they're, and building arbitration, I think it's probably a good example, because invariably the arbitrator has legal and either architectural or building or other relevant construction qualifications experience. So, but I don't personally think of arbitration as an ADR process. And in practice, by the time you set up an arbitration of any duration, provide rooms, pay the arbitrator, it's actually, in many instances, more expensive than going to court. And the appellate process can be more difficult to try to engage than if you have a traditional judgment from a court. So, but Paul, the point about the style of ADR, what is called loosely mediation varies enormously, and I have to say that, having appeared for a number of parties in commercial mediations and been a mediator for not very long, I think that under the umbrella of mediation there's a huge range of procedures, and that probably the only things they have in common in every instance is confidentiality and voluntariness. Virtually everything else It's largely a question of what seems to be getting us somewhere, which we've stayed with. When we get bogged down, we back off and look at coming at it some other way.
So you see flexibility is one of the
Huge
highlights.
flexibility.
Enormous.
Yeah, and you very quickly in mediation, there's an old saying that until lunchtime the mediator is facilitative, after lunchtime the mediator is evaluative. Now in the pure model of mediation, as I understand it, there is no scope whatsoever for the evaluative phase. But one of the major reasons, apart from his charm and good looks, that they would have Professor Collier mediate in a family law matter is that he just happens to know a hell of a lot about what's likely to happen if it gets to court, and it will only be a matter of time before both parties in private sessions want him to give some evaluative input. Now, you know, that's, and it's, I can't say going to commercial mediations, a couple with former High Court judges, they almost give you a judgment and stop. But it works, and quite works. So I mean, I don't think much turns on the attempt of the judge to put a name on the ADR process. It'll sort itself out, and at the end of the day, if there's goodwill, there's been genuine disclosure, and it's amazing how often in commercial and other mediations, it's premature because there's either been inadequate
investigation.
Yeah, and I think that's when we talk about practical impediments, and that's one of them. But if the parties are desperate to avoid going to court, they'll get there with within that loose framework of confidentiality and voluntary participation, and things will kind of, from an academic perspective, it's probably not good that it is so, but from a practical perspective, things will kind of take care of themselves.
Sort themselves out.
Yep.
Can I just, in conclusion, but not to make it too light in terms of time, the etiquette and ethics of ADR practitioners. Have you noticed a change from when you first went on the bench? What were your expectations of practitioners appearing before you, and did you get what you expected?
I can't comment necessarily in an ADR role because we don't see them perform as ADR practitioners. I had, in my last few years on the bench, conceived, I believe, that more recently admitted practitioners were quite aggressive and quite determined to be, what shall I say, non-cooperative with their fellow practitioners. It occurred in the court situation almost from the very beginning of correspondence going to and fro. And I admit that I'm a Luddite, but to my mind much of that has to do with the use of computers, where an email is typed and sent without anyone bothering to look at it again 24 hours later. If that is carried over into arbitration, then in my view that imperils the prospect of a settlement being reached, not because of the parties, but because of the legal practitioners. And it seems to me that a course such as you and Ian are running, which perhaps can take some of the ginger out of them when they are appearing and working in ADR, is a very good thing, because there is no doubt ADR is not only here with us, it's the way of the future. It's going to be relied on more and more. And it will be a tragedy, and I think I use the word advisedly, if a system that's going to determine well over 90% of disputes in all fields is in any way interfered with because the practitioners can't work in the manner that I believe is required of practitioners in court or in arbitration. Common courtesy to each other, to each other's clients, to the mediator or to the judge, and an ability to look at the situation bearing in mind the other side might just have a case. instead of many practitioners you and I have both known, Ian, who are good advocates, but can never approach a matter from the point of view that the other side just might have something that could do you a fair bit of damage when it comes out.
Yes.
So these are all the realisations that the practitioners, young and old, have to take into mediation, as they have to take into running any piece of litigation.
I agree with that. What David's saying, I think, is borne out by what you find in some of the literature where they talk about mediation at two levels, where the mediator has to mediate between the lawyers before being able to even begin to mediate between the parties, and unless, regrettably, but understandably, unless the mediation between the lawyers results in some kind of accord in terms of courtesy and ethics and procedure, through no fault of the mediator or the parties, it never gets to the point where the parties might reach a settlement. And I think I've experienced it in practice. I've noticed even in commercial mediations, good mediators discourage opening statements from counsel in the presence of parties.
Yes.
And I think that's probably confirmation of a lot of what David's saying. That, it's a different skill set, although I don't know that it's all that different to the skill set when you're in court running a case. It is all about being seen to be reasonable.
Okay.
You may not actually be being reasonable because your instructions may not permit you to be reasonable, but as counsel, I think your abiding obligation is to use your best endeavours to be seen to be reasonable. The best advocates, the best negotiators are humble. Conversely, I think there's an inverse relationship between ability and humility, which I very much doubt my learned friend here would disagree with as a proposition.
Not for one moment.
Indeed, very insightful. When you consider perhaps the reluctance of some practitioners to embrace ADR, could you identify some ethical considerations where they might see self-interest to drive their desire to proceed with the adversarial outcome as opposed to an ADR outcome? In other words, there's more money involved in a full-blown hearing as opposed to a matter that could resolve the matter in several hours by way of a mediation, perhaps. To me, there seems to be the potential of some ethical considerations here.
I think there are. In commercial litigation, consistent with what happens in commerce generally, everything withdrawn. Most things are approached from a risk assessment perspective. And in that context, you look at what is our range of possible outcomes from best to worst, which is a feature of all civil litigation. It's not you win, you lose, generally in civil litigation, but you assess your prospects of success, you factor in your costs, both if you're successful, if you're unsuccessful, very much like you do in mediation with those acronyms, the best alternative to not
The BATNAs and
whatnoters and whatevers.
Mm-hmm.
And I think a lot of lawyers haven't got to that. Haven't moved on. They haven't moved on with the times and don't approach it in that sort of big picture context. And I think you need to, if only from a negligence perspective.
Are you suggesting that not every lawyer would make a good negotiator in the area of ADR? They don't make it. There's a different skill set from that into mediation with the ADR.
Look, I couldn't agree more. I was in a mediation, 4-party mediation in March, and 2 banks, farming properties and other properties, parties hopelessly in default, banks just staying their hands, and the solicitor for one of the parties, he just literally spat the dummy, stormed out. Following Monday, as they had said they would, the banks moved in, it's likely that by the time mortgagee sales occur, there will be nothing left. And this was a case where probably $35 million worth of assets, $20 million worth of debt, all in default. You've only got to factor in forced sales at one end, default debt at the other, $10 million wasted. Now, that was solely because the lawyer was the sole impediment to a sensible commercial resolution in that case. It was terrible.
Gentlemen,
I shall ask what you said to me.
He wasn't there to say anything to. He stormed out. He said, "Well, if that's our last offer, if you don't want it, I'm going. And by the way, I'm going on holidays next week. You can." Basically, said to us, "You can all get stuffed."
But that's going
And the
to
client that would have cost the client literally millions.
be.
So, Paul, what you say is absolutely right. There are some people who shouldn't go near ADR, but they don't think that. They think everybody else in the platoon is out of step.
Sure.
They will generally not go to mediation, or if they do, they'll insist on a mediator of their choosing who they perceive wrongly will be favourable.
Yes, self-interested.
And that is in fact what happened in this case. The mediator we had was not the mediator that the solicitor in question wanted. So,
That's going to cause more trouble. I don't like mediation, I'm not comfortable with it. It's silly, it's non-productive, rather than the practitioner who sits back and thinks that I'll do other things, simply to build up my costs. I think that's really, in fact, if you look at it one way, if a practitioner were determined to get as much as possible out of a case, of course they'd go to mediation.
oh yeah,
They take every step along the way.
exactly.
And ADR is one of those.
I agree. I think it's a topic for another time probably, but that's part of the potential abuse of ADR.
Yes.
David,
You're right.
you're spot on about that.
In concluding comments, what are your thoughts now that you've been on the bench now, off the bench now adjunct professors here at the law school, that we now have a new core law unit called Alternative Dispute Resolution? What are your respective thoughts on that every student now coming through our undergraduate program must undertake a core law ADR unit? What are your thoughts on that, gentlemen?
I think it's appropriate and proper, because whether they go into my field, which was family law, whether they go into common law, whether they go into huge commercial matters working for banks or even government departments, who are supposed to be model litigants, I so suppose.
Well, yeah.
All of those things would require, as part of any litigation process, save and except, I suppose, the local court, and even they have local court mediators they refer to, they're going to have that skill in a way that we didn't, or weren't required to have that skill when we started. These people have to. Ian mentioned that horrible word negligence, and part of the practice of law these days, like it, which I certainly do, or love it, as Ian's example practitioner who stormed out is concerned, it's here to stay. If they don't learn it, and don't have an introduction to it, we're sending out practitioners who aren't properly qualified to act on behalf of members of the public or corporations or whatever. Their clients are going to be disadvantaged if they don't have at least a background and an understanding of ADR.
I agree. Knowing that this is going to be edited, I can probably utter some heresies that won't find their way into the final edition, but having recently, with Paul's encouragement and assistance, tried to teach an ADR unit here, I think part of the impediment to the students embracing it and acquiring more skills in the area, and Paul and I have talked about this, but I won't breach the confidence of those discussions. It's a pity, I think, that they don't get more opportunity to practice what's involved. Having spent half a day with Paul in April when the students did a full day it was fantastic to watch them develop during the 3 hours I was here. What it was like by the end of the day when Paul was throughout, which Paul was present the whole time, I don't know, but I think there's a tension between the theory and the practice, and if there was a way that the students could take on board the theory, which underpins the practice, we know that it's not just suck it and see, as it were. But I think their enthusiasm for it would be much greater because they appeared to me in class to be enthusiastic about anything that involved practical.
The feedback was very
practical
positive
stuff.
indeed.
Yeah, but it's a work in progress, I gather, from what Paul's told me, and it's a work in progress that's worth pursuing for the reasons David says. It's here to stay. It's very important. And the other thing too is for young lawyers, and it comes back to what we've said about going to court. You get a tenancy dispute. No one's going to go to court chasing $3,000 arrears of rent. You have a dispute with a panel beater. No one's going to go to court over a dispute with a panel beater over $2,000 motor car repairs. The plumber does a bad job. You're not going to go to court over a grand. This is where young lawyers can make their mark because they come into a firm, they're on the bottom rung of the firm.
That's the sort of work they'll see.
That's the stuff they'll get, and if they're good at it, the client wants to buy a house, they come back. The client wants to start a little company, they come back. I just think it's a terrific, the stuff we three cut our teeth on, defended negligent driving charges and stuff like that. That's not there anymore. This is the new entry level, I think, the new entry level work for young lawyers. And this university, I think, has a great opportunity to really not corner that market, I suppose, but really make its impact in that area, and it would be good for the students, good for society, just good all round.
Excellent. Well, thank you, gentlemen. That concludes the second of our series on Views from the Bench. Thank you.